Okay, I think it's time to start. So once again, thanks everyone for joining this presentation. So today, this presentation is sponsored by Vasavi Association Victoria, and I will hand it over to Satya Garu to start the presentation.
Okay, thank you, Shyam. So, thank you. I welcome everyone who have for the today's session on the will writing, and also I welcome Theo Apostolopoulos from State Trustees. Sorry, my pronunciation of the last name.
That's fine.
So I would like to take a moment just to introduce the State Trustees. So State Trustees are the state government owned organization, and as the public trustee for the Victoria, they work for the social purpose, and one of them is the will planning and the trustee services and the financial services, super and so on. So, and State Trustees has been there for a number of decades, 75 years providing these services. So today we are collaborating with State Trustee to bring this event to you. And we have Theo with us. Theo is a relationship manager for the trustee services. Theo has been for a close to 2 decades with the State Trustees and a industry experience in the financial superannuation. And he has a specialization in the power of attorney, will writing, and disease administration. So we are very fortunate to have a Theo with his extensive experience to provide us this valuable information on the will writing and the next steps. And so I welcome Theo, and I extremely thank on behalf of the VAV committee that you took time today to bring this to us. And so I pass it to you now. And after this session, maybe you can advise the attendees what are the next steps or what are the possibilities. So then towards the end, we can chat few minutes on those steps as well. Okay. Thank you very much, Theo.
Not a problem. Thank you so much. And good evening, everybody. As was rightly pointed out, my name is Theo. Call me Theo. It's fine. Everyone else does. The picture that you saw of me earlier on, or in the previous slide, was when I was much, much younger. So hopefully I've matured since then. But yes, I have been with the organisation close to a couple of decades. I am, my official role is a relationship manager, but obviously as a relationship manager, you're expected to know, pretty much anything and everything with regards to the products that our organisation offers. We've been in existence for a great number of decades. We are the Public Trustees of Victoria. We were referred to as the Public Trustees of Victoria, but we undertook a name change back in the mid-90s, and we became State Trustees, and we've retained that name since then. Okay, may I have the next slide, please? You might as well just tap all the way through just to get everything there. All right, lovely. So I guess with any organisation that exists, we all, we have a mission statement. And our mission statement is basically that together we support Victorians to protect their financial well-being at all stages of life. And obviously, as we progress through life, our circumstances change. And as such, we need to reflect and work out what would be best for ourselves and our loved ones moving forward. So as an organisation, we offer a number of products, and we deal with a number of products. And the products that we actually are appearing on the screen there. So we in the last financial year, we've seen in excess of 17,000 online wills and retail will kits and powers of attorney kits taken up by the Victorian community. One of our products that we do offer the general community is enduring power of attorney financial administration. And what that basically means is people who voluntarily seek out our service, they have us manage their financial affairs, even if they do, whilst they still have capacity, with a view of if they do become unwell some stage in their lives, they've already made the decision of who they would like to manage their affairs when they are no longer able to. And under that arrangement, we've got in excess of 500 clients. The flip side to that is we also look after a number of clients over 10,000, as the slide states there, of those vulnerable people, those people who have some form of a disability, whether it's they're born with a disability or they've acquired a disability during their life, and they are no longer able to look after their financial affairs, and they require somebody in their corner to manage their financial affairs. That process goes usually it does go through VCAT, and VCAT is the Victorian Civil Administration Tribunal. And the tribunal looks at the facts, looks at the medical information or reports that are also submitted at time of application. And based on all that information, they make a decision as to which party is best placed to manage that particular person's financial affairs. Okay. And the parties that are appointed are usually family, friends, or independent organisations such as state trustees. Okay. We look after in excess of 8,000 estates and trust beneficiaries. And we also have what we call a charitable trust, where people bequeath funds or monies in their will that they leave. It goes into this charitable trust arrangement, and those monies actually go into the community to benefit the community as a whole, whether it's for certain works, whether it's supporting children who are unable to pay for schooling. We set up scholarships, whether it's opening or funding or partially funding playgrounds for people of the third age or disadvantaged people, those sorts of things. So we support projects, and we have been supporting projects since 1994. May I have the next slide, please? Yep, you might as well click on it, so that way. So state trustees, you'll ask me, or you'll ask the question of, are they public servants? Once upon a time, we were public servants, but when we undertook the name change and we became state trustees, we actually embarked on a standalone and became a standalone entity. We are still connected to the Victorian government. We have one major shareholder, and that is the Department of Treasury and Finance. Okay, so we have a connection to the state government. It's a dotted line rather than a bold line. So we're not actually a government department as such, but we're a standalone organisation that has a connection and is connected only to the Victorian government. On your screen, you'll see the various divisions that State Trustees is broken up into. So there's the financial administration division, which predominantly deals with people who are appointed by VCAT to state trustees to manage their financial affairs because they are no longer able to. We've got our corporate services division, which encompasses or includes HR, finance and investment teams, our IT department. So those core back office type of support areas that provide that support to the greater organisation. We've also got professional services, and that includes divisions or departments which include legal services or legal, taxation, financial planning, and genealogy. And genealogy is the area where we have a number of people who actively investigate, identify people who are deemed to be next of kin but have been estranged, especially if there is an estate that they may actually be be deemed to be a beneficiary. With genealogy, a lot of legal practitioners actually seek out that service because obviously they don't have the resources to do any investigative work. And as a result, our genealogy staff are able to locate people, whether it's within the state of Victoria, outside of Victoria, and the 5 corners of the world. And we're even talking remote areas of the world. So we're able to track a lot of people. Given a little bit of time, we do actually track a lot of people. And finally, the last division of which I'm a part of is the trustee services. And that includes areas that look after powers of attorney or clients who have voluntarily come on board and appointed us. Our will writers, people who prepare wills. We've got our team who look after and manage deceased estates under that executive services area. Our trust administration look after trusts, our charitable trust foundation, and obviously our strategic initiatives, which is basically our marketing area and our insights team. So that's State Trustees in a nutshell. Okay, if there are any questions, and I'll be directed by Satya or any of the committee. If you want to ask any questions as we go ahead, as we go along, I'm happy to field them. Or whether you want to take, you're happy for me to go through the presentation and then field questions at the end of it. I'm really not fussed. I'd like to make it as interactive as possible because I think there's a greater value for all in this forum to be able to ask questions. There might be some questions that are repeated. I don't know if you want to ask questions via a chat room, and that could be relayed to me. I'm open to any way you'd wish to have a dialogue, ask questions, and for me to answer them.
Theo,
yes,
I feel like I feel like you can take the questions, but what I'm thinking is it's better people to ask questions related to the slide, and if they have any questions related to their personal circumstances, it's better to take them towards the end of the session.
Okay, I'm perfectly happy with that.
Yeah,
not a problem. May I have the next slide, please?
Sure.
I have a question. I'm Praveen here.
Yes, Praveen, how are you?
Yeah, I'm fine. Thank you.
That's good.
But I don't know whether I have already posted my question earlier while registering, but I don't know whether my questions have been addressed. So I joined a bit late right now. And my question is very straightforward. Uh, the I don't know whether you are aware of the power of attorney regarding that. My question is regarding the power of attorney. And I'm an Indian citizen. I'm right now over here, and there's some property. I have multiple properties, and I want to give the power of attorney of a specific property to my mother. And how is it possible for the Indian citizens who are in Australia to give a power of attorney which is valid for in India? Yeah, that's my question.
Okay. So I'm happy to answer it. So let me just get this correct in my head. So you want to give a power of attorney to your mother.
Yeah.
She's residing in India. Is that correct?
Yes, she's in India.
Yep. So is that for Indian assets that are held in that jurisdiction?
Yes.
Okay.
Yeah.
But you're residing here in Australia?
Yes.
Okay. So my understanding is you will need to make contact with somebody who can prepare a power of attorney who's across the Indian jurisdiction.
Mm-hmm.
With regards to setting up a power of attorney that applies to that particular country, appointing a particular person who will then manage in your absence and on your behalf those assets that are held that are located in India. Okay.
Right.
The powers of attorney that are actually prepared here in Australia apply to Australian-based assets.
Oh, okay. So
Okay.
for Indian-based assets, we can't prepare anything, or else the only better thing what you say is to get a format of the power of attorney from India, and can the attorney generals or notary can will they work out?
Okay, what I would
I
probably
take that
suggest you
question.
do, yeah, and I'll give you an example. My late father had power of attorney in Australia for assets in Australia, power of attorney in Greece for assets in Greece. Okay, now what he actually did, he went to the Greek consulate here in Victoria and organised it. So I'm assuming that if you get in contact with the Indian consulate here in Victoria, they would be able to provide you with a list of legal practitioners whose specialty is Indian law that will be
Right.
able to direct you
Yeah.
in preparing an Indian power of attorney. And the same thing applies for wills. Okay.
Oh, okay.
If you hold assets in another country, obviously the jurisdiction or the laws in that country are different to the laws in this country. Okay.
Yeah.
So
Okay.
obviously there's a different format, there's a different approach in preparing a legal will.
Okay. No worries.
So I guess
Thank
as
you.
your first contact, it could well mean that you get in contact with the
Indian consulate.
consulate
Yeah.
or the embassy, and
Yep.
then they'll be able to guide you.
Sure. Thanks. Yeah.
And
That's
Theo,
Then-
I would like to take a moment. Just information to all the attendees that many of us are in that board where we have some interest in India and we have some interest in Australia as well. So the Indian jurisdictions are different. So what we are trying to do that we are trying to collaborate some legal experts in India, and in coming weeks or very soon we will organize another similar session how to manage the Indian assets and how to manage the will in India and all. So for today, I request everyone to keep
okay.
the discussion to the Australian jurisdiction or Australian laws. Yeah.
Okay. Got it. Thank you.
And
Right.
one more announcement, please. In the interest of time and audience, I request everyone to please, keep the questions to the slides that are being discussed. And if you have any questions that are specific to your personal circumstances, please ask them towards the end of the session once Theo is done with the presentation. That way, he can complete the presentation and he can share all the information that are relevant for this webinar. And after that, towards the end of the session, we can ask what are the personal questions are. Thank you for understanding.
Okay.
Over to
So
you.
obviously, given that we've been in, we've been in operation for a great number of years. As an organisation, we need to change. Obviously, the landscape changes, laws change, and so we obviously need to change. We adhere to every so often the Ombudsman, Victorian Ombudsman, comes up with reports and findings of how we can better ourselves. One of the findings was a greater interaction with clients, and the clients could be our direct clients, could be beneficiaries of deceased estates, which basically ties in with recent changes to the Guardianship and Administration Act of 2019, where under that particular act, which is current at the moment, one, irrespective of whether they have or they don't have capacity, a client needs to come along in the journey and include them. That is very important because it has an inclusive approach. So we've actually embraced that, and we're finding that a lot of our people are actually working with their clients, regardless of whether they understand it or not, working with their support network, whether it's their immediate families or it could be their care worker or any other support person. And the other thing, which is basically what we're doing this evening, is partnering with community and industry organisations about getting messages across, working collaboratively so people are aware of what they need to consider as they progress through life, and providing that support, similar to what we're doing this evening. So we consider it to be a somewhat new operating model, but we've been doing it for the last couple of years, but we like to sort of detail that when we do presentations such as this one. Okay, may I have the next slide, please? So what do we do? So we look at, these are the service, these are the products that we offer the Victorian community. We offer powers of attorney, financial administration, trusts, executor services, which is basically managing and looking after deceased estates. We've got our Victorian Will Bank, and we've got the Victorian Will and Powers of Attorney Registry, and finally preparing wills for the folk in Victoria. So these are all the various types of products that people can avail themselves if they wish to have state trustees assist them. Okay, next slide. The overarching and important thing that we need to be aware of is capacity. And capacity, I'd just like to take a couple of minutes discussing this. Capacity is what we refer to when a person has an understanding, is able to provide direction, and is and knows exactly what he or she wants, okay, with a particular service. So if we were to use an example of appointing a power of attorney, the person is referred to as a donor needs to know A, who they wish to appoint, B, their understanding of the document and the legal requirements and the ramifications of appointing somebody other than themselves to manage their financial affairs, and 3, what their rights under the legislation that governs a power of attorney allows them to do and what they can't do. And one of the important things is that if they wish to change any aspect of that document, they need to have capacity to do so, okay? The other important bit is that the person is able to freely instruct his or her attorney at any time whilst they have the mental decision making on how their finances are to be managed, okay? The flip side to that is a person who no longer is deemed to have capacity and he still does require somebody to manage their financial affairs, and that is basically through what we call financial administration, or it could be a guardianship order. And guardianship is a specific order that deals with lifestyle decisions. So financial administration and guardianship are two separate things that in a person's life. One revolves around financial management. The other is about decision-making on lifestyle. And lifestyle will include things such as where a person is to live, who they live with, and who they're allowed or who is allowed to, I guess, communicate, liaise with the person, okay? And that is done on that VCAT side of the fence, okay? So VCAT makes that appointment. Who determines capacity? It's usually a person's treating doctor. Can't be me, can't be Satya, can't be the next person, unless Satya is a medical practitioner. Well, then I stand corrected. But it's usually the person's treating doctor that makes that decision based on medical evidence. Okay, and from that point onwards, they can then take the relevant path to get the relevant assistance. Okay, does that make sense? Yep. Okay. So the powers of attorney, there are 3, obviously, powers of attorney. I don't know how many of you in this forum have a power of attorney, but the powers of attorney did actually change. They changed on the 12th of March of 2018, and it specifically dealt with the powers of attorney that related to medical, and it also changed the guardianship. What was once called as the enduring power of attorney guardianship document has now been replaced by supportive, okay? It's just a change in words, but the general, role, the general idea is exactly the same. And the medical power of attorney is exactly the same. It's just a change in words. So where it was previously known as medical, it is now known as medical treatment decision maker. If anyone had prepared, whether it's a financial power of attorney, a medical power of attorney, or a guardianship document prior to the 12th of March of 2018, it is still a valid document. So you don't need to rush out and prepare a new document. that would satisfy the current legislation, because all documents prior to the 12th of March of 2018 are still recognised. Okay, we've got a hand up there. Should we take that?
Hi, Theo. My name is Satish. Just regarding to the medical doctor who's making this decision,
Yes.
can we pre-choose this doctor when we are in good condition?
Sorry.
Like,
Okay.
can we choose this doctor when we are in good condition? Meaning that, can we nominate who should be this? Like, either if you're going to a GP or a doctor who's familiar with.
Well, yeah, it's usually a doctor that has seen you more than, you know, a few times, you know, a couple of times. You can tell pretty much straight away if a person is doctor shopping, and it does happen, especially if we're talking about an elderly person who is coerced in appointing usually a child, is usually coerced by a child, and that said child does actually go doctor shopping. They don't usually go to the person's usual treating doctor, because there might be things that the usual treating doctor might suggest or say based on medical history of the person that will then maybe not allow them to be appointed as the attorney. So it is your usual doctor that you see, whether it's for the common cold, whether it's for your flu jab, or whether it's for any other reason. It's your usual doctor that would provide that report.
Okay, so I think if I just, I get what you're saying, but
Yep.
The question is, do we have option to nominate that doctor when we are in good condition, or, for example?
Oh, absolutely. So look, I mean, if you're wanting to appoint somebody to manage your financial affairs, look, I mean, if you're young, less than 60 or 70 or 80, you live independently, you're fiercely independent, you're managing your affairs, but you're starting to slow down and you can't pay your bills and things like that, but you're still of sound mind, then it'll be a conversation that I would have with that person. And there'll be certain things that I'll be asking them about, that will give me some comfort that they still are with it. And it's usually things such as, I can tell you what my shares are, how many shares I have, and what my bank accounts are. They can reel off, their balances. They can tell you who the previous Prime Minister was. They can tell you what day of the week it is. They can tell you who won the last year's grand. They can tell you a number of things. Yep. And that you get some comfort. But if there's any element of grey, we would usually say to that person, it's best that you get a letter of capacity from your treating doctor to make sure that your understanding of the document, because it's a very important document that you're going to sign, and you're going to appoint somebody to look after your financial affairs. So if you're in good health,
great, thanks.
Yeah. So if you're in good health, but you're 85 years old, we usually would ask for a letter of capacity to safeguard yourself. Okay. Especially if there's been some history with the family dynamics have changed. Or there's you're wanting to change a current financial power of attorney and appoint somebody else. Okay, it gives you an opportunity to make that independent appointment and voluntary appointment, and your GP will provide you with that comfort that yes, you still have capacity, and yes, you can do as you please in terms of appointing somebody else. Okay.
Great,
Does
thanks.
that answer your question?
Theo,
Yes.
We'll keep the question answer session at the end, and we have already received a number of questions. We are gathering them.
Yep.
So we'll discuss the question answer at the end. So
That's
if we can keep going, that will be good.
Yep. Okay. Next slide, please. Sometimes it can be a little bit difficult, to just breeze through them and
Yes.
the questions. So I guess as a financial attorney, a person's responsibilities are broken up into three categories, and that's protect, collect, and pay. So you're protecting assets, you're protecting entitlements, you're you're making sure that lodgement of tax returns are done, financial planning to make sure that, whatever assets or any funds that may sit in a bank account are working for the client. The collection of, income, whether it's through a pension, whether it's an overseas pension, whether it's a superannuation pension or any other income, whether it's investments in term deposits, those sorts of things, that forms part of that collection heading. And finally, the one that happens to us all the time is payment of bills. So, whether a person's living in supported accommodation, such an aged care facility, as an attorney, you need to pay the monthly fee or the monthly bill. Then there's bills if you're living at home, electricity, gas, water, all those sorts of things. Maintenance is another one. Insurance is a very important one. As an attorney, if you're looking after somebody's financial affairs and they're living in their own home or they've got properties, you need to make sure that the insurance is up to date. Because if the insurance lapses, the property is broken into or it gets burnt to the ground, then there is a degree of liability on your part because you haven't done the right thing. Okay. So that's basically what an attorney's role is. So with financial administration, which is that VCAT side of things, it's pretty much the same sort of responsibility. The only difference is here between financial administration and under a power of attorney is a financial administrator, once they're appointed, it's up to them to decide what's in the best interest of the client or the person. Under an enduring power of attorney, if something needs to occur or if something needs to happen, if the client still has capacity, they've got to run it by, the attorney needs to run it by the client that they're representing to seek his or her instructions. Okay. So under financial administration, you're acting in the best interest and managing pretty much everything. Under enduring power of attorney financial, you're managing everything at the direction of the client. Okay. If they lose capacity at some point down the track, then you're looking after the total financial administration or the total finances of that person. Okay. Because they're no longer able to provide instructions. You've got to step in and manage pretty much everything if you weren't managing everything to start off with. Okay. That makes sense? Yep. Okay. Next slide, please. So this is the way that the VCAT applications run. So I won't go into it, but it's usually incapacities identified, lodgement of an application, a hearing date is set by VCAT. Then a hearing is conducted. The member that presides over that VCAT hearing will make his or her judgment. It's binding. And then whoever is appointed as the administrator, the member or VCAT will then decide the duration of that appointment. The duration usually is between a minimum of 12 months to a maximum of 3 years, after which they all come back to VCAT. They have a look to see how things are progressing. And if everything's progressing well, then they reappoint the current financial administrator. If at some point during that period of time, the financial administrator is not acting in the best interest of the client, then the hearing can be made again to have the administrator removed and appoint somebody else. And sometimes what has happened in the past for us is we've been asked we've been appointed by VCAT where we weren't the first choice. It was either a family member of a friend or somebody close to the client, and they haven't done the right thing. So they appoint us as an independent party. Okay, so that's the VCAT process. Next slide, please. You might as well bring them on. Okay. So that's all about powers of attorney and financial administration. So that's basically whilst we are still alive. So when we depart or before we depart, the important thing is to get our affairs in order. And how do we do that? We do that by putting preparing a will. So by preparing a will, it means that you've provided for the people in your life, the ones that you love. You avoid any potential disagreements between beneficiaries. And you also provide instructions to your executor as to how your estate is to be managed. And part of that direction is your funeral arrangements. Yeah. I just did a will this morning for a gentleman, and I said to him, okay, we'll use his name as John. Not that John is his real name, but we'll call him John. And I said, John, now let's talk about funeral arrangements. Have you thought about what you'd like to do in that space? And he had a bit of a think, and he said, I'd much prefer to be cremated rather than being buried. I said, okay, that's fair enough. And what about your ashes? What would you like for those? And he said, I want my executor or my family to take my ashes. Are you ready for it? And take them down to the beach, a particular beach, and spread them in the water. And I said, that's pretty good. I said, but why that particular beach? He goes, because as a young kid, I remember walking down, because he lived pretty close to the beach. As a young kid, I'd walk down holding my father's hand, and we'd go to the beach during summer and spend all day, and I loved it. And they're the memories that I hold near and dearly. And that's the way I want things to happen. I said, that's fair enough. And so that was actually put in his will. So you can do those sorts of things. A lot of people say, okay, if I do pass away in Australia, and this happens in a lot of cultures, in a lot of communities, I want to be repatriated back to my birth home or my birthplace. Okay. And they leave instructions to that effect. And it's up to the executor then to manage that side and fulfill the wishes. So there's a number of things you could do. All right, next one. So these are the common mistakes with not preparing a will. The important bit is not seeking legal advice, especially in those instances where there might be a degree of complexity with regards to your estate. And complexity could mean, you might have been married, you've divorced, you've got, you've partnered up again, and your partner's brought, children from a previous relationship, and you've got that blended family sort of approach. You might not want your, children from another relationship benefiting from your estate. So by putting a will together, by getting some legal advice, they will actually step you through the process of what you can and what you can't do. Not witnessing the document is an important one, because when a person signs their will, they have to have two witnesses present. The two witnesses need to be a minimum of 18 years of age, and they can't be the executor, and they can't be a named beneficiary in the will. Okay. Another common mistake is not appointing an appropriate executor. Now, do people know what an executor's role is? Because if they don't, there is a couple of slides further down, which I'll talk to about what the roles of an executor. Okay. All right. So not appointing an appropriate executor basically means that you might appoint an older person or a younger person who is of age. They may not be able to manage it. They may not have the resources nor the understanding. So it's all about getting somebody who's appropriate. Okay. Can I have the previous slide, please, sir? Okay. Not considering your dependents is another important or another common mistake. Some people leave certain family members out. It's important to provide the person taking your will instructions, the reasons behind why you're leaving out of your will a certain family member, especially if that family member is dependent on you. Okay. And that could be something along the lines of, look, I'm leaving Mary out of my will purely because I have actually provided for Mary whilst I was still alive and gave her $50,000 to go towards a deposit for her to purchase a property. And I think that I have adequately funded Mary in that regard. Now, whether they decide to leave something as a token for Mary in their will depend on themselves, okay? And what we generally say is sometimes it pays to leave something small, because that way people may think, okay, well, at least they've left something for me. I don't have to submit a claim against the estate for a bigger piece of the pie. Not that it doesn't stop people, but it also allows the process of bringing a claim in front of a court, whether it's through arbitration or a court environment, of where the presiding person may turn around and say, well, they've provided for you whilst they were alive. They've also given you something when they've passed. What else do you want? I think it's fair and reasonable that you have been looked after. So I don't really think you have a claim. So those sorts of things might be important as a token, okay? The mental capacity is not documented. Again, this capacity thing comes in, where for a person to prepare a will and provide instructions under that will, they need to understand the document and to also be able to provide instructions to whoever's taking or preparing the will on their behalf, okay? It's important to document the mental capacity, especially for an elderly person, and especially if the family dynamics are such where somebody within the family might turn around and say mum or dad had no idea what they were instructing, the person taking the will, preparing the will, because they had lost capacity. Now, that can be challenged by way of having a current medical capacity letter at time of preparing the document, where it clearly stipulates that yes, on this day or during this period, the person did have capacity. So we can't question it, because capacity is capacity. They had it, and no one can sort of say otherwise, okay? And it's usually a person's treating doctor that will do that. Another common mistake is not preparing a will. The will can't be found, especially if prepared one, because it's important to note here that for an estate to be administered, the original will needs to be used. A copy or a certified copy or a photo of an original will is not sufficient. The Supreme Court of Victoria, in that probate's jurisdiction, will need the original document. And this is why early in this presentation of the types of services that we offer, we had that will bank. There is no central wills registry in the state of Victoria where anyone who prepares a will can register it. There is no central place to hold your will. There are some options. One, you can keep them at home, whether it's lying somewhere or in a safe. Two, you can pop it into a bank, into one of those safe custody packets. But sometimes there's a charge. So if that's what you want to do, you'll need to contact your bank and find out if there's an annual fee. I know that a couple of banks do charge a fee. I'm not too sure what the exact amount is, but that's an annual fee to keep it. Or three is to submit or ask state trustees to keep the original document. Of course, you'll have copies and certified copies that you can give your executor and for you to have at home. And we can store it in our safe custody area, and that's a free charge, and that's free. So there's no charge. So there's no charge to place it in there, and there's no charge for taking it out. So there's no entry fee, and there's no exit fee, and there's no ongoing fee. The reason we did this is because no one else does it, and because the state trustees, we like to give an opportunity for everyone to store their legal and important documents. And the other thing that we do actually keep and store are the original documents for enduring powers of attorney. Okay. Next slide, please. How are we going for time? We going all right?
We are midway. We
Yeah.
got 45 minutes more.
So that's okay. No problem.
Okay.
Keep going, Theo.
All right. So these are just some facts. So half of adult Victorians have never made a will. That's about, and 16% of those have no idea how to prepare one. Of those half, 19% have experienced a family member or a friend passing away without a will in place. And then 29% of Victorians think they're too young to write a will. But of those, 41% of the 29% are people aged over the age of 30. The interesting thing is a lot of people think that if I prepare a will, I'm going to die the next day. It's not the case. It's similar to going on a holiday when we're allowed to go on holidays overseas, interstate, where you take out travel insurance, where you take out, insurance to cover your luggage, to cover your medical expenses if you fall ill or you fall over and you end up in hospital. We all drive cars. We take out insurance for our vehicles. We take out home insurance for our properties. We take out insurance on our lives, on our family, on our pets. It's no different. Okay. Will is a similar type of insurance. You're insuring on how your estate is to be handled when you're no longer around. Okay. And of the half of Victorians who do have a will, 60% of those people have not kept it up to date. What I say to people such as yourselves in this forum, those of you who have a will, the rule of thumb is every 3 to 5 years, you pull out your will and you ask yourself this very simple question. Does my current will reflect my circumstances, my current circumstances? Okay. If it doesn't, you can change. You can update your will according to your circumstances. If it reflects your current circumstances, the address that appears in your will that you have has changed, right? You don't have to go rushing out, updating your will just to update your address. The average of a person changing or moving properties is every 7 years. So if I was to live to 84, let's say, and I had prepared my first will at the age of 20, let's say, and I moved between the age of 20 to the age of 84, that's 64 years. 7 sevens are 49, 7 eights, what is it? 9 sevens are 63. That's 9 times I've got to update my will. Okay. It's not required. Why it's not required? Even though if your address is your previous address, but your assets or your will is current, they will take, this is from a legal point of view, your last residential address as your current address. So that isn't an issue. The only time you need to update your will is if your beneficiaries change, if any assets that are named in your will have been sold, if you've got new beneficiaries or you've got children that have come in on the scene or grandchildren that you want to leave something, it's those triggers. If if a loved one or a partner passes away or you remarry or whatever the case may be, they're trigger points to update your will. Okay, it's pretty common sense. Yeah. Next slide, please. All right. So this is the role of an executor, as I mentioned earlier. So there are 6 areas of responsibility for an executor, and I don't know how many of you have been appointed as an executor or have actually fulfilled the role of an executor, but this is basically what an executor will need to be across. So making funeral arrangements, obtaining or finding the original wills, making sure it's a valid will. You need to find out, you need to locate all the beneficiaries named in the will. You need to then submit an application to the probate's office which is part of the Supreme Court, which is that middle bottom picture there, probate duties. You know, any assets, you need to make sure that you are fully aware of all assets in the person's name, that they're secure. You need to adopt a legal approach dealing with legal issues of defending the estate against any claims. You need to advise certain third parties, such as, you know, Centrelink if they're in receipt of a Centrelink pension, or the superannuation fund if the person's a self-funded retiree, or any overseas pension organisation. Organise and contact other third parties, such as, you know, utility companies, you know, home insurance, all those sorts of things. Redirection of mail is another one. That would have to be the youngest person I've had in the presentation. That's cute. You know, management.
Everyone mute yourself, please.
Sorry?
No, I'm asking everyone to mute themselves.
Yeah, that's fine. Another thing is looking after a person's, I guess, accounts, affairs, getting in contact with the bank, letting them know that the person's passed away, but you're the executor, providing them with a copy or a certified copy of the will. Sometimes they may ask you for a certified copy of the birth certificate, you know, those sorts of things. So there's a number of tasks that an executor has to fulfill. And obviously the final task will be distribution of funds, assets to the named beneficiaries. Okay. Next slide. Yep. So this is where state trustees is involved with the management of the deceased estates under our executor services. So we can we administer more estates than anyone else in the state of Victoria. Similarly, we also write the most wills in the state of Victoria. Okay. So whether it's administering an estate in its entirety, or administering an estate under what we call an executor assist. So in that middle square there, you've got a full administration, estate administration offering that we offer, or an executor assist. And what executor assist basically means is that you might be an executor that's been appointed by a person, but you still want to retain that role. However, you might want to farm out certain tasks. You might say, oh, I'm not quite sure how to lodge a grant of probate. We can do that under the executor assist. Or I don't have time, or I don't know who to contact to do a final tax return on behalf of the estate. We can do that. So there's a number of things that we can do under that executor assist. Okay, and that's like a fee for service. And obviously, if we're appointed as the executor, you know, the way that we approach it is that we're impartial. We take on full legal responsibility, and that's what differentiates us from lawyers or solicitors in the community. You might approach a lawyer or solicitor and they might say, yep, happy to take it on board, but the legal liability still remains with the named executor. If we're appointed, that responsibility gets transferred, as does the handling of bank accounts and the investment of funds that come in. Normally what happens is, if we're calling in funds on behalf of the estate, whether it's realizing funds from a sale of a property or shares or whatever other tangible asset, it sits in the account of the estate. It does earn interest, and that interest that's earned, that then gets distributed along with whatever the amount is to the beneficiaries. Okay, so that's another difference between us and legal practitioners in the community. Okay, next slide. And as I said earlier, where can I store my will and enduring power of attorney? So, we can hold it on behalf of yourself. As I said, there's no charge. If the document needs to be taken out of that storage area, what we would probably request is a letter and a photo ID to confirm that we're giving the original document to the right person. Similar to, any other transaction that you might sort of do with a bank or another financial institution. Okay. That's a free service, as I said. Next slide, please. This is about trusts. So we can set up trusts. You can set up trusts in your will. You can do testamentary trusts. You can do minors trusts, and that's for minor children under the age of 18. If you're an executor and there is a trust that sits in that will that is to the benefit of the minor child, depending on the vested age of that child, you as the executor will take on the responsibility and the role of the trustee of that trust until that minor child reaches the vested age. Okay, so I'll give you an example. So if I set up a trust and I've got a grandchild, that grandchild is 6, and I've put an amount of money in that child's name, I might say when that child reaches the age of 18, then my executor / trustee will then pay that out to that child who's come of age. Okay. The other thing is, if that child needs some of those funds for their schooling, in other words, for their education and things like that, you as the executor or you as the trustee of that trust could actually pay some of those funds, right, for the education of that child. You might say, well, I don't want the child receiving that, that amount of money when they turn 18, but I want them to receive it at the age of 21. You can do that also. Or you might say, well, the age of 21, they might benefit from it when they turn 25. You can also do that. Okay. So they're usually the vested ages that people set up trusts within their will. Okay. And the other thing is you can set up a family trust whilst you're still alive. You can transfer certain assets into the trust, but bear in mind, if you transfer assets from your name into the trust, you no longer own that asset. It is owned by the trust and it benefits the beneficiaries of the trust. Okay. So if you're thinking about trusts, always get some advice. If you wanted to know a little bit more about trusts, you can actually contact us and we can actually put you in contact with one of our trust experts too. Okay. So that's trusts. Next. And that's basically the disclaimer. So we're pretty much towards the end of the presentation. So all the information that I've provided, ladies and gentlemen, is basically based on facts. What we always say is seek some legal advice, do your due diligence, see what works for you, what is your best in your best interests. Also, making sure that you've got, the documents in place that will cater for your loved ones, your nearest, your dearest sort of thing. Okay. And finally, the last slide is how you get in contact with us. So, and as you can see, don't leave it to chance. Okay. You can contact us via our general number that appears there on the screen. If you needed any further information or, specific information on any of our products, or whether it's our fees and charges, you can jump on our website, which is the 3ws.statetrustees.com.au. In the search engine, you can just type in, a couple of words and it'll bring up the relevant page. If you wanted to make contact with me in the future or anything like that, or you have a question, that's my number. Satya has my email address. If you want to sort of email me with any questions, that's fine. The other thing is, and Satya said to me, so what have you got to offer my members? I said, okay, well, what we're actually doing is, and this is part of the the collaborative side of things. If anybody in this forum, or whether it's another family member that wasn't able to make it this evening, or you might have a friend who wasn't able to make it this evening, or anything like that, but specifically for this group, if you want to prepare your will or your power of attorney, we're happy to provide a discount. We usually discount it, by about 10%, or if you're a healthcare card holder or a senior card holder, we usually just, offer a 10% sort of a discount. But given that, we've recently we've reached out to one another and, have made this presentation possible. Happy to provide a 20% discount on any wills or powers of attorney to the members, regardless of when that takes place, as long as you can get in contact with me via email, or if you do ring the general number, and just let them know that you've attended a presentation of mine, and they'll make it happen. The best way to do it is you can either contact me directly via email, or you can contact, I'm dobbing you in now, Satya, you know that, right? And he can, collate names or people who are interested, who want a further discussion, and then we can have a bit of a chat, and he can forward that on. And that's not a problem. At the moment, what we're doing, and it's unfortunate, because I don't know about everyone else in this forum, but I absolutely like or prefer the face-to-face. At the moment, we're doing a lot of video will appointments and appointments appointing enduring powers of attorney or attorneys under the enduring power of attorney document. So it usually takes about an hour. And yeah, you can always ask for me, I guess. I'm in this role for another couple of months, because I'm just filling in for somebody who's on extended leave. But we can certainly, if you wanted to have a chat to me, or you wanted me to prepare a will or enduring power of attorney, just let me know, and we can tee up a time, and away we go. And hopefully when lockdown is done and dusted, we'll be able to meet face to face, and that way have a more pleasant, I guess, experience. No, not pleasant experience, but an experience where we're in the same company as one, rather than these screens. I don't know about you, but I'm over screens. I've just had enough of them. But anyway, it is what it is. But if there's anything that's urgent that needs to be done, we're able to come out. I know I'm able to come out because I do have permits and I am exempt. Because in my other role, I do actually go out and see vulnerable people because there is a need. So there's a way, there's ways around it. Okay.
And Theo, we have received a number of questions in the chat. Over 20 of them. And there are the few questions kind of a similar or a repeat that, different people have asked. So what we'll do that, we will share the screen with those questions. And
Yep.
if you can respond to them.
Absolutely.
And if you have already obvious ones, if you're covered, or it's a repeat questions, maybe you can skip past in the interest of the time. So,
Yep.
Thank you, Theo.
Not a problem.
Yes. I will read out those questions, because I don't think I can share the screen. So what I'll do is I'll read out those questions and we'll go one by one.
Actually, I've got the questions here. So do you want me to take them?
Yes, please. No. Okay. I think you're talking about the questions in the chat, right? Yeah. We have collated all those questions.
Oh, okay.
We got the full list. Actually, while asking people to register for this session, we gave them an option to pose the questions while registration, and so we got the complete list. So the first one, okay, there are some of the questions are already answered by you as part of this presentation.
Yep.
How to provide GPA for my blood relative for a specific property in India? I think we have already discussed because it's outside of Australian jurisdiction. What is the procedure for the will preparation for properties and children? Which I think you have already answered as part of the presentation. Am I right?
Yep.
Yeah. What type of scenarios do a will written will cover?
So what type of scenarios?
Does a well written will cover? Well written will.
A well-written. So what scenarios? Okay. So what about, so a well-written will would cover the scenarios of funeral, would cover the scenario of who you want to appoint as the person or persons to manage your estate when you're no longer around. It's also important that if you're wanting to gift anything, whether it's money or a tangible product such as jewelry, parcel of shares, a property, a car, anything like that, it's best that you specify each item. So you specifically write that into the will, okay? So you specify it so that way there is no ambiguity. It is clear as day, okay? And I'll give you an example. I did one last week, a will, and a lady said, I have 3 daughters. I have, as ladies do, of course, love jewelry, right? I have a necklace, a pearl necklace, earrings, and she said, I want it specified in my will and I want it to go to daughter number 1. So you specify pearl necklace, 45 centimeters in length, 2 earrings, 1 pearl ring. That's one set. The next daughter received gold 24 karat cutlery set. So that was specific. So she stated exactly what it was. I had another person who prepared a will about a month ago, and they said, I have 2 paintings in my living room, a painting of this particular image and a painting of that particular image. And these are the painters' names. I want you to specify, I want to specifically name them in my will. So that way there is no confusion. So you can do that. So that's important. Another thing is obviously the funeral, as I said. Some people want to donate their bodies to science. You can nominate that, you can stipulate that in your will, or you're part of the organ donation program. You can stipulate that in your will. Okay.
Yeah.
Obviously, if a person has subscribed to organ donation, obviously they'll have all the paperwork, which one would assume and hope that they provide that to their executor, so they're fully aware. Okay. Now, there are certain cultures where if a person passes away, they have to follow a particular set of
rituals,
rules as part of the that funeral or cremation process. There are certain cultures that within 24 hours they've got to be, buried or cremated or things like that. There's a certain observation of certain cleansing processes. You can put all that in your will. Okay. It might not be a 3 or 4 page will. It might be a little bit longer than that.
Okay.
But the more you put in there, the clearer it is for the person who will be managing your will. Okay. That makes sense?
Yeah. Perfect. The next one,
question.
What will happen if we write multiple wills? Which one will be considered?
Okay. Good question.
Classic.
So if you write multiple wills, the will that's valid is the will that is the latest dated will. Okay. So I might have written a will in 2020. I might have written a will in 2019 on the 1st of November, 2019. I need to change it 3 or 4 months later. I might have just written the will today. It is today's will that's the valid will. Similarly, enduring powers of attorney are the same. It is the most current document that replaces or cancels or revokes the previous documents. So it's the current one, the latest dated one. Okay, does that answer the question?
Yeah. The next one, I think you already answered. What are the steps involved in will writing? Which we already discussed, what is required and what are the steps and who are all involved in the will writing.
Yep.
The next question, please. Is making a will necessary if you only have one heir?
If you have one child?
Yeah,
Okay.
one legal heir. It's not, they didn't mention child. They mentioned if we have only one heir. H-E-I-R.
H-E-I-R.
Legal heir.
Heir. Okay, one
Heir.
heir. Okay,
Yeah.
yep, one heir. Okay. So for example, okay, this is where it gets a little bit interesting. If you pass away without a will and you're survived by one heir or one family member, it's usually either your partner, and partner could be your wife, your de facto, or you're survived by a child. That is your immediate family, yeah? And there's only one, but you might have a brother, okay? If you die without a will, it will go to your next of kin, which is either a partner or a child, or in the case of partner and children, it'll be distributed according to the laws of intestacy. But your brother may actually say, I want a piece of that. That's where they put in a claim. But if it's only one person, what happens if that person, okay, you've prepared your will today. You've appointed that one person, or you haven't appointed that one person. What happens if that person dies? All right. And there is no survivor. There's no one in the family. What happens then to your estate? The only person, or the only people who are going to benefit is the State Revenues Office. And you may not want that. Okay.
Yeah, cool.
All right. So the important thing is here, and I'll give you an example. We had one gentleman who appointed us as his attorney at the age of 94, but he was still of sound mind. He had no will and he was worth $10 million. He made his money when he retired on the stock market in the late 80s, early 90s. It's post the 87 crash, yeah? And pre-GFC. He had no one. He had outlived his mum and dad. He had outlived his brothers and sisters. Aunties and aunts had gone, cousins and cousins, nephews. There was no one. And we had said to him, if you die, no one's going to benefit. It's going to end up with the government, in the government's hands. And do you want that? He didn't know at the time. So every time we'd meet with him, we'd have that conversation amongst other things. And we said, you're not getting any younger. You may become unwell, or you may suddenly pass. And then what happens? And that started triggering his thinking process. And he said, well, okay, yeah, I want to prepare a will. I don't know who to leave it to. And so we started talking about charities or people or organizations that have touched or have been quite close to him during his lifetime, to the point where one day he called us and he said, I'm ready to prepare my will. Okay. So this is going on for about a couple of years. So at the age of 96, he prepared his will and he was still of sound mind, but we still checked with his doctor to make sure that he was still of sound mind. He prepared his will and he left his estate to 4 different groups. He left 25% to the Royal Children's Hospital, 25% to the Peter MacCallum Cancer Centre. He left 25% to the Deafness Society, and he also left 25% to his old high school for underprivileged kids as part of a scholarship. Okay. He died a year later, and there was only 4 people at his funeral. Okay. Having made that decision of preparing his will, because he had no family, no heirs, this gentleman has touched hundreds of people through his forward thinking and the way that he structured his will that went across 4 charities. So that's another thing that you can consider. Okay,
Cool.
that's why it's important.
Theo, we got a big list of questions to go through.
Yep.
In worst case scenario, can we nominate someone from overseas? I think the question is about, the executive or, nominee. Can we nominate someone from overseas?
Okay, is that to be your attorney, or is it to be your executor, or both?
The question is very vague. and they
Okay,
don't
I'll
talk
assume
about it.
I'll assume it's for both. Let's say it's for both, or either or.
Yeah, let's make it
Okay.
clear.
The problems that appointing somebody from overseas will present is that sometimes they cannot be able to manage or physically be present to manage assets or make decisions. You've got to factor in language, you've got to factor in law, the legal jurisdiction, and you've also got to factor in time differences. Okay.
Yeah.
So even though it's 8 o'clock here in Australia, in Victoria, right? It's, and I'm using myself as an example. It is 1 o'clock or 12 o'clock in Athens, in Greece, or it could be 10 o'clock in the morning in London, or it could be the middle or past midnight in New York. You see what I'm getting at?
Yeah.
And sometimes communicating or doing things via email, especially when a decision needs to be made urgently, there's a problem. And not everyone works 24/7. A lot of places work from 9 to 5 or 9 to 5:30 or 8:30 to 5:30. And some places don't actually work over the weekend. So there's also that to consider. Okay.
Got it. Next question. They gave a scenario. It's a scenario question. A family consists of husband and wife and a child. Husband is writing a will. He bought a property before his wedding. Husband and wife together bought a property, another property after their wedding. Can he transfer pre-wedding property to go to his daughter and 50% of combined property, which was bought between husband and wife, to go to his parents through his will?
Is this at death?
Sorry.
Is this at death?
DEF, DEAF.
So that's so they want to transfer property over to somebody else.
Now, the question is, husband has bought a property before marriage,
Yep.
and after marriage, both husband and wife bought together another property.
Okay, so there's 2 properties, one in sole name, one in 2 names. Yep.
Yeah. Can he transfer the pre-wedding property, which he bought solely, to go to his daughter, and 50% of combined property? Okay, combined means the one that both husband and
The jointly owned. Yep.
jointly owned property, to go to his parents through the will.
At death.
At death, they didn't mention. Maybe yes, maybe. Yeah. I think it's a simple answer. I think we can do anything in the will.
Okay.
So whatever
All
they
right.
mentioned.
So let's assume the person who owned the property whilst they were single, and then has come into has married and together has bought property together, but that other property is in the sole name. The person who has that property in sole name in his or her will can put it in a way where that property goes to my child. Yes, you can do that at my death. Okay.
Yeah.
With regards to the jointly owned property, that can go to anyone else. However, if one of the parties who owns that property dies and leaves the surviving person, ownership transfers to the surviving person. That second property that's jointly owned will only be given to a beneficiary, right, when that second person dies, unless in their will they have prepared it in a way where they have a common interest in the property, by, and when I say a common interest, I'm talking about a beneficiary through a will has an interest in the property, even though that property is owned or has had the ownership transferred to the survivor. Okay.
Yeah. Yeah.
All right. Again, that is a complex sort of approach, which will require legal advice.
Sure.
Okay.
Yeah. Cool.
With regards, and I'm going to preempt one of your questions. Let's say that I get married, I purchase my property with my partner, but we've got no children. But I prepare a will. And in my will, I say, in the event that I die, everything goes to my partner. But in the event that I have children in the future, and you can put it this way, that they will receive a percentage or X dollars from my estate or anything that's in my sole name. Okay. Because you can actually put in a clause or instructions for future additions to the family, whether they are children or whether they are grandchildren of your children. Okay. Yeah. If you're preparing a will and you've put your children as your beneficiaries, and your children have their own children, in other words, your grandchildren, but one of your children dies before you do, you can put an instruction in there that if the amount or the gift or whatever it is fails to go to my child who has predeceased me, and they are survived by children of their own, that I want their portion, that is the portion of the deceased child, to go to their children, i.e. my grandchildren. Okay.
Yeah.
So there's that succession. And I'm sure there'll be one of those questions that came up in the chat.
Yeah. Yeah. The next one is, what happens if there is no will in place, which you already answered it. The next one is, what happens for family trust properties if there is no will in place?
What happens to
family trust properties if there is no will in place?
Okay, well, that the laws of intestacy will apply to all assets that are outside of that family trust. Remember, the family trust would have assets in the trust's name. Yeah.
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 Okay. The next one, how does it get executed in case if the owner suddenly dies and owner is the only person who knows about the will and no other person in the family knows about the will? So
Okay.
there is a will in place, but it's hidden from anyone. What happens?
You contact state trustees and hope, and fingers crossed that the original will is in our will bank.
Yeah. Okay. Okay. Yeah.
Look, the funny thing, look, that I make a joke out of it, but you know what? It's true. It's a fact. We get a lot of people calling state trustees and they ask the same question. Has this person made a will with state trustees? And then it's up to us to say yes or no. And as I said, the unfortunate thing about it is there is no central wills registry. Okay.
Yeah. Yeah.
Sometimes people say, well, I think there's a will, but I don't know if it's valid, or I don't think there's a will. And then the estate gets started. As part of that process, you advertise. Okay. You advertise, whether it's online or in a newspaper, about your intention to apply for a probate. And you usually give people 14 days to respond. And that usually flushes out any wills, because there's a lot of legal practitioners out in the community who have people who look at the death notices and notices about intentions to act in an estate, and then they cross-match their that information with their database and see if they've got a hit. So there's a number of ways around it.
Yeah.
Yeah.
The next question, I think you already answered. Where do we register the will?
Where do we store the will?
We register, yeah. We register.
Yeah, look, I
for
mean,
the-
you can do it. You can store it at home, or you can store it in a safe at home. But sometimes, unfortunate things happen, and properties burn to the ground, as was the case back in 2009 with the bushfires. You can store it in a safe custody pack at the bank, but ask your bank if they're going to charge you for that, whether it's an annual fee or a one-off fee, or you can actually store it with us free of charge. They're your options.
Yeah. The next question, I think, is similar to what we've gone through earlier. If we have only one son, is it necessary? Is it necessary to do a will? Which you already answered it.
Yeah.
Yeah. Next question: can we write will for Indian properties here in Australia?
Can you write a will
For Indian properties? Yeah, Indian assets.
So can you write a will in Australia for assets in India?
Yeah, that's correct.
Okay. As I said earlier, the answer is you really shouldn't and you really can't, because of the jurisdiction is different.
Mhm.
And if you remember, I said, it's best to get a will in that jurisdiction to cover assets in India. Where do you start? As I said, you either ring up the Indian embassy, or you might know of an Indian legal practitioner who does wills for assets overseas in India.
Yeah.
Or ring up the consulate, and they'll be able to provide you with some advice and a direction of where you could go. Yeah.
Sure. Yeah.
Or you might have to contact somebody in India, like a notary public, that could prepare a will for you. But again, the problem there is the time difference. Yeah. I don't know how far behind is India from Australia?
4.5 hours during non-daylight savings.
Okay, so 4.5. So it's not too bad.
Yeah, there is a lot of overlap. Yeah, agree.
Yeah. Okay, that's good. That's good.
The next question, I think, which you already answered. Can we give will executors who are in overseas? I think you already answered that. And the next one is pros and cons of preparing a will, which we already gone through during the presentation. The next one, what happens to the assets if there is no will and the whole family is deceased?
Okay. So what happens to the estate if the whole family is deceased and the deceased is gone? Yeah. So what happens to the assets?
Yes, sir.
Okay. State trustees becomes, or under legislation in Victoria, becomes the executor of last resort. Okay.
Yeah.
It is then our responsibility to use our genealogy area, as I mentioned earlier in the presentation, who will try to retrace and potentially may find a distant relative somewhere in the world. If we can't and there isn't anyone, then usually what happens is it ends up at the State Revenues Office as public funds.
Yeah. Okay. The next question: if there is no executor or the executor passed away, will state trustees act as the executor?
Okay. So are we assuming that there is a will?
Yeah. Yeah.
Okay. And the executor's passed away?
Yeah.
Okay.
Or no executor?
Sorry?
Or no executor?
Okay. There are no executors. Okay. All right. This is the important bit. I'll talk about both sides. If you've got a will and you've appointed a primary executor, always make sure you've got a substitute. The reason why you need to appoint a substitute is that if in the event the first executor passes away, loses capacity, or just doesn't want to do the role, it then defaults to your substitute. Okay? If your substitute doesn't want to do it either, then they can decide who they can nominate or appoint to manage the estate.
Yeah.
Okay.
Yeah.
And that could either be ourselves or a solicitor.
Yeah. Next question: does state trustee can charge any fees if they are the executors?
So as an executor or as an executor, we do actually charge a fee depending on the value of the estate. And like, I mean, if you jump on our website, our fees and charges are there, but we are gazetted by the government to charge no more than 5.5% on the value of the estate. Having said that, that 0.5% is GST because it's a service. However, it is based on the level of contact and the amount of complexity and I guess how much time to serve. So if the estate is, you know, one that I've passed away and I'll leave behind my partner or my wife or whoever that is, the laws of survivorship apply. So the fees are very minimal.
Yeah.
If, however, it takes, you know, 9 months for the estate to be wound up, and in that there's a claim against the estate that is the executor, and that applies to a lawyer too, obviously, that they need to defend the estate against, and obviously there'll be some additional charges that form part of that 5.5. But what we do as an organization is we take a cut at the start, we take a cut towards the middle in terms of the fees of what, not we take a cut of fees, but we take a snapshot. Let me say a snapshot at the start, a snapshot somewhere in the middle to see how much time and effort we've put in, and then a snapshot at the end, and then we work out what the fees are going to be, but we can't charge more than 5.5. A legal practitioner might charge you for the grant of probate. They might charge you for, I don't know, doing searches, all those sorts of things, and then they'll charge you their own charge in 6-minute increments. Okay.
Yeah.
Depending on who's actually doing the work, it could be a junior lawyer, a mid-tier lawyer, or it could be the principal of the law firm. And each one has a different hourly rate. Yeah.
Yeah. Got it.
So and they will charge you as you go along. We don't charge as we go along. We do it at the end.
Okay. Cool.
Okay? That's what it is.
Next question. If, as per the will, if the beneficiary is a non-Australian who resides overseas and the person is not interested to travel to Australia to take the benefits, can state trustees dispose the assets and transfer the realized funds to the person living overseas?
Okay. So any beneficiary who lives overseas and is named in the will cannot refuse it. Okay. No one refuses it. In the 16 years that I've been with this organization, I've never seen somebody say, I don't want the money.
No, but the person is not willing to travel to Australia.
You don't have to travel to Australia to take your benefit.
So that is the question. If the person is not ready to travel to Australia, can state trustees dispose the assets and transfer the realized funds to the beneficiary?
Yeah. Like, I mean, if we're, look, okay. So if there is a beneficiary who lives overseas, they don't have to travel to Australia to receive their entitlement. Okay. If we're appointed the executor in a person's will, and we realize an asset, and part of that realizing of the asset goes to an overseas beneficiaries, then we will contact the beneficiary and take his or her instructions as to where they would like us to place the funds, and it's usually in a bank account.
Yeah.
So they don't have to come to Australia.
Is there the next question, is there a standard form for the will preparation?
Is there a standard form for the will preparation?
Yeah.
What do you mean by that?
I think that's a very vague question. Not sure. Let's move on. I understand.
I can throw some light because I don't know who asked that question though. In the post office, they sell a will kit. So that is a standard one, you write it. So that's what they're asking. That
okay, all right.
The trustee have similar.
I can answer that. That will kit in the post office is one of our will kits. That's something that we've actually done with Australia Post. The reason why there is a will kit is because we believe that anyone over the age of 18 should have a will. And you'll probably turn around and say, what would a 20-year-old have in terms of assets? You'd be surprised. They have plenty. They might have a part-time job. They have a bank account that their money goes into. Part of that part-time job, they might have superannuation. That's an asset. They might own a vehicle, or they might own, you know, an iPad, a laptop, whatever. They're all assets. Okay,
thanks.
you'd be surprised. Okay, so those will kits are good when you're starting out. Those will kits are also good if your affairs aren't complex. So if you're preparing a will kit and you're saying, I appoint person A to be my executor and my beneficiaries are persons B and C, you know, and it's a very, very simple 50% split, that's fine. But as long as they sign it and have two witnesses at the time that they are signing the document, and they're using the same pen, and they're all in the same room. Okay.
Yeah.
Anything that's complex where, you know, there might be quite a number of different assets. It could be, you know, a number of, you know, 2 or 3 bank accounts, might be a term deposit, there might be a small partial of shares, there might be a property, there might be, I don't know, children from another marriage or whatever the case may be. That's when the complexity starts to creep in. That's when we say, if you are in that position, you need to get yourself a consultative appointment with a will writer, where you can sit down and construct the will together. Okay.
Next question: Can state trustees store the will which is prepared by a lawyer, but not the format, not the same format that state trustees use?
Okay. Yeah. All right. So if you've prepared a will with a lawyer, right, and you want to have it kept safe in our will bank, you can do that. It doesn't have to be a state trustee's will written by state trustees, yeah, for it to be in the will bank or in that storage facility. Could be a will kit, could be a will that's been prepared by a legal practitioner. It's not a problem.
Yeah. Next one. For Australian citizens with properties and investments in both Australia and India, is it possible to create a single will that covers all the properties and investments across the world?
No, you can't.
Okay.
The jurisdictions are different.
Yeah. Okay.
You might actually have property interstate. So let's say you've got a property in Victoria, and you've got an apartment in Queensland in the Gold Coast where you go up every summer and spend 2 or 3 weeks up there.
Mm-hmm.
That's different because it's Australian assets.
Yeah.
Because when you're preparing your will, and it should be anywhere and everywhere. But that anywhere and everywhere is in Australia only.
Got it. Yeah. Cool. How do we approach a will if we are joint owners?
How do you approach a will?
Yeah. How do we write a will if we are the joint owners of joint owners? I mean, if the properties are jointly owned, how do they write their individual wills? That's what my understanding is. Okay.
So essentially, if you're married and you want to prepare your will, we can prepare a will is for one person only. It's not a married couple. So if it's a married couple or a couple that's together, you can't have one will. Each person has their own individual will. However, if you're in a situation where you're married, you can have mirror wills. The wills mirror one another. So, for example, I might decide, let's say, I'll use myself as an example. So, my wife want to prepare our wills. We go down, we prepare our wills. I appoint her as my executor. I put her as primary. Substitute might be state trustees. If I was to die, everything goes to her, or if I was to die, half of it goes to her, the rest goes to, you know, my 2 children. Let's say, for example, if I had 2 children, I've got more than that, by the way, I've got 3. And the same thing goes for her will. Whatever I've put in mine, she puts in hers. So they mirror one another. The only difference is our names.
Yeah.
And who the executor is.
Yeah.
That's it.
Yeah.
And obviously the signatures on the bottom.
Cool. Next question is storing a will in probate services offered by Supreme Court same as storing the will with state trustee?
Okay. Can you repeat that first part? Is storing a will
In probate services offered by Supreme Court, probate services, PROBATE.
probate services Supreme Court is basically the area where a grant of probate is usually applied to. Okay. So when somebody dies, they die with a will. Whoever the executor is, they make an application to the probate's office of the Supreme Court. Okay.
Okay.
It's the probate section of the Supreme Court that then looks at the will, makes sure it's valid, looks at the list of the assets, looks at the death certificate, obviously, and then once they've identified that everything's correct, everything's fine, it's the real will, it's the current will, then they issue the grant of probate. They don't actually hold wills.
Yeah, cool. Next question, I think you already answered. How many years a will is valid?
How many
years the will is valid for?
Oh, the will's valid for forever unless
Yeah.
something changes where you need to make a change.
Yeah, otherwise there is a will written later to that.
Yeah, look, I mean, I can tell you right here and now that a will that is prepared today will not reflect your circumstances in 5 years' time or 10 years' time because things change.
Yeah.
Okay.
Yeah.
If my will says that 50% goes to my wife, and the remainder go to my children, and in the next ensuing 5 years, let's say my wife no longer is my wife, right? Then I've got to change my will, or in my will I have bequeathed a property to one of my children. Let's say I've sold that property. That child's not going to benefit from that property because it's no longer owned by me. You see what I mean?
Yeah.
So I can guarantee you one that's done today will probably not be the same as it will be, saying in 5-10 years time, because things change as we progress through life. That's why I said earlier, every 3 to 5 years, you ask yourself the question, does this will document that I have reflect my circumstances?
Yeah, got it. Next one is, what are the legal liabilities of an executor?
What are the legal liabilities
of an executor?
Of an executor?
Yeah, will executor. Yeah.
Yep. Okay. So the legal liabilities is that he or she will need to adhere to the instructions of the will.
Okay.
If in the event they've obtained the grant of probate, or they haven't obtained the grant of probate, and they sell a property, or they sell an asset and they distribute the funds, and there's a claim against the estate, then it's going to be quite difficult to ask for that money to come back, or those funds to come back. You see?
Yeah.
You can't go selling things without the grant of probate, because the other thing is a little thing called intermeddling. And what intermeddling means is that you have already done certain things without gaining the permission. Okay?
Yeah. Okay, the next one is, what if the named executor does not want to hold the responsibility anymore due to the change in circumstances.
Yep. Okay. Well, then it'll do if the named executor, the primary executor, does not want to be responsible or want to be the executor, it'll default to the substitute. Yeah. Executor.
Yeah.
If there's no substitute, the executor can then say, I don't want to do it. I want to authorize somebody else to do it.
Yeah.
They're well within their right to do it.
Yeah.
Whether that somebody else is our organization or it's a legal practitioner. However, an executor cannot relinquish their authority once the grant of probate has been provided. It's too late.
Yeah.
Okay.
Okay.
Because it's their name on the grant that shows that he or she is responsible, and they need to look at and manage the estate until the end.
Yeah. Yeah. Cool. We got some people who want to pose the questions. I see that Vani wanted to ask a question. Please go ahead. Vani, you there? I think you're on mute. Please unmute yourself.
No, I mean, Vani
Okay.
already asked question
Okay,
earlier.
perfect.
He didn't put his hand down.
Sure. Okay, perfect. Next one, does the state trustees commission as an executor or as stipulated at the time of writing the will, or the rates that will be applicable at the time of executing the estate?
No, it's after. So it's not stipulated in the will.
Okay, got it. The next one, what is the approximate cost of preparing a will?
So the approximate cost of preparing a will. Okay. Says he quickly looking. I know it off by heart, but I want to make sure I give you the right.
Okay, and before you answer that question, just a small announcement to the audience. Hello, everyone. As mentioned, right, Theo has generously agreed to help us, all the attendees in preparing their wills, and he has offered a 20% discount, which is more than what usually they provide to their customers, just because of the association we are having with you. So I request everyone to please make use of this benefit, and I hope it will help the community. Go ahead, please.
Okay. So in terms of preparing a will, if a person appoints state trustees as the sole executor and they're under the age of 60, the cost is $200. If a person appoints state trustees as the sole executor and they're over the age of 60, it is $97. If they appoint any other executor, if the person is under the age of 60, it's $330. If they're over 60, it's $200. Less than 20%, obviously.
Yeah.
Okay?
Yeah. Cool. Next one. Will it be applicable? Does the will is applicable across the states if we move between the states?
Yes, it is.
Yeah, it's not because it's the jurisdiction is whole Australia.
Yeah.
Right.
It is.
Yeah. Yeah. Okay. Next one. Do we need to list the assets individually in the will?
You don't list them in the will. Unless you are gifting assets to certain beneficiaries or to certain people that you want. Okay. As I said earlier in my example, you can actually list items such as jewelry, other items that have been in the family for a little while or for a long time. It's been passed on from generation to generation. It could be property if you want, or it could be a monetary amount. Okay. But you don't necessarily need to list it, because it'll all fall into the pot of all assets in terms of realizing and then subsequently distributing to the named beneficiaries. Okay. The only time that you list the assets is when you're applying for the grant of probate.
Yeah.
Okay. And they are the assets only appearing in the person's name. If it's an asset that's jointly owned, it's jointly owned. Under survivorship, it'll go to the surviving other owner or partner or loved one.
Perfect. We got, I think some of the audience want to pose the questions directly to you. So please go ahead.
Yes, so Theo, just a follow-up question. If we don't list all the assets, as a executor, will state trustees find out all the assets, tangible assets that are for both the, both the people listed on the will?
Yep. Look, I mean, if we're appointed the executor, we do title searches for properties, right?
Mm-hmm.
We would also look at any other assets that may be held with banks.
Yep.
Any assets such as shares through the share registry. What else? Vehicles, obviously, through Vic Roads. So we can, if we're appointed the executor, that's part of the process in confirming assets. And the other thing is, with regards to property, if we're appointed the executor, we will actually visit the deceased person's property to see if there's any paperwork in there or organized for paperwork to be retrieved, which will give us a better understanding or a deeper understanding of what assets the deceased person held. And making sure that the property is secure, is insured, especially if we're looking after the estate, because if anything happens to that property, then we're liable, you see? Yeah. So we need to make sure we take adequate steps to ensure that all assets are protected. That's the bottom line.
Thank you.
You're welcome. Okay. What other ones?
Sorry. Hi, Theo. I have a question.
Yes.
I have shares not just in Australia. Like suppose I have shares in US market. Will they be in the will as well, or that has to be again as? I know it's like a mixed question, but will that be again a separate jurisdiction?
We're talking about assets in America.
Shares in the market. In the
it depends on which platform you use. If you use NAB Trade, they still form part of your NAB Trade account.
Okay. Thank you.
That's I'm being facetious there because I know, because I do exactly the same thing. They all form part of the one account through NAB or whether it's CompSec or whether it's any other platform that I guess my understanding is it's backed by a bank.
Thank you.
You're welcome. Any other questions?
No, I think that's all the questions we had today.
Mm-hmm.
So I just one quick announcement that those who haven't registered, I encourage them to register. We have reopened the registration form. The reason is that we are, as a follow-up, will reach out to you the deals and other discounts and others offered by state trustees, and also the other products that state trustees may offer. So we are in discussion with them, and so that if you register, you will be one of the people to get that benefit. Okay, and I really appreciate everyone's attendance, and I convey very special thanks to our friend Theo. Such an elaborate and such detailed presentation, and you took the questions so patiently. I really appreciate your time, and you demonstrated an extreme level of experience and knowledge in this space.
Thank you so much. I appreciate it. Look, I mean, I'd like to thank everybody for listening to me, giving me the opportunity, the association giving me the opportunity, or giving us the opportunity. And look, I mean, if you've got questions, if you want to avail yourself to any of our products, just let me know, whether you want to message me directly through email, or whether it's through one of the committee members or Satya or anyone like that. Just reach out. ask a question if you want. And look, it's not going to cost you anything if you ring me up or you send me an email and say, hey, I thought of this question. What happens here? I'm more than happy to give you a call if you leave a number. It won't cost you anything. I'm not going to charge you for it. It's if it's advice that will then allow you to make an informed decision, because information, being educated is a powerful tool, because it's important that you make the right decisions, you ask the right questions and as many questions that you can, because that will then influence and allow you to make a more well-informed decision, I guess, that relates to yourself. So that's important. So I thank everybody for listening to me, as I said, and be given the opportunity. As I said, thanks to the guys for organising it and reaching out. If you've got any questions, hit me up. I wish everybody a good evening. Stay safe. Those of you who are, or all of us who are in lockdown, I can't go for a walk now. That's fine. I don't care. We've only got 2 minutes. Stay safe. Look after your families, your loved ones, and always think, take every day as it comes, because it's important. It's maybe we all be blessed that we have what we have, the people around us, and we'll all get through it together. We've heard that slogan for the last 20 months, but we'll get over it. So, and I wish everyone all the very best. I thank you and have a good evening, everyone.
Thank you.
All right, take care.
Thank you, Theo. Thanks a lot.
My absolute pleasure. Bye for now.
Thank you.
Thank you. Bye.
Thanks everyone for attending this presentation. I'm ending the presentation now. Thank you.
Yes. Thank you. Bye,
Thank you.
guys.
Thank you.
Bye.